Good morning and welcome. Please come in and take a seat. My name is Yolanda Cabral, and I have provided mediation services for the last 20 years, and I am privileged to mediate this car accident. Briefly, parties, we have Attorney Jones. He's the lawyer for AVX Transportation. Mr. Charles Smith is the claim representative for AVX Transportation, here to provide any type of settlement authority. And Attorney McKay is a lawyer for Mrs. Reed, the plaintiff. I'd like to thank the parties in advance for choosing the mediation process and providing me with the confidential statements in advance. Some quick house cleaning. There are refreshments in the back, and please, I ask that you please help yourself. We'll provide snacks about 3:30, and lunch will be provided at noon. We will take regular stretch and bio breaks. And for some safety measures real quick, if we need to evacuate, there are 2 exit doors, one to the right and one to the left. In the event of the earthquake, we ask that you duck, cover, and hold. And moving forward, I ask that you turn off your cell phones. And if you notice that there are any text messages or phone calls that you must take, just wave your hand and we'll take a break for 10 minutes. Okay, to ensure that this process runs smoothly, I ask that we all respect each other while we're speaking, refrain from any type of interruptions. This will keep all the discussions productive and respectful. Okay, be assured that everybody's going to have a chance to talk. At this point, I just ask for everybody's honesty, willingness, and good faith to resolve this matter. Let's see, thank you for signing the agreement to mediate in advance. However, I will go over in my opening statement what this agreement to mediate means. Also, I would be remiss if I didn't mention that defendants offered to pay the entire mediation fee contingent on reaching settlement today. Full and final settlement. So thank you. Okay, let's see, real quick. Let's discuss your rights and your entitlements. Voluntary. As we all know, this is a voluntary process. All parties here today are here of their free will. However, you must negotiate in good faith. Confidentiality. Confidentiality is huge. I need all of you to talk openly. So understanding what confidentiality means, it means that you will hopefully speak and disclose anything that's on your mind, and you'll feel comfortable discussing any type of facts or even emotions or fears you might have. Confidentiality is not only something that we agree upon, but it's actually a California rule of court, which states basically that any and all communications, discussions, writings disclosed during this mediation remains here. During the times that I speak with you separately, all these discussions, likewise, are completely confidential, including mediation briefs, deposition transcripts, my notes, any type of paper substance that I receive are all confidential. And at the end of this mediation session, I will actually shred. Also, nothing can be used against you in court. So anything that's been said today cannot be used in court, and I cannot be subpoenaed to testify about anything that was said at court. However, there is one exception, and that where I must breach the confidentiality, and that's due to the safety of an individual. For instance, if there's any type of threat of violence, now or in the future, any type of criminal activity that's been disclosed, unfortunately, I must breach the confidentiality. Neutrality. You're all entitled to a neutral mediator. So at this time, I can say this is the first time I've met with any of the parties to discuss this issue, and I don't know you out of the office, and if this is an inaccurate statement, I need you to disclose that now. Otherwise, we will move forward. Again, I'm here. I only have the power to. I don't have power to make any type of decisions. My sole purpose as a mediator is to assist the parties in an amicable resolution. The mediation process. At this time, you get the opportunity to speak your mind and to tell your story. This is an opportunity for you to present your case in the best light as possible. Keep it truthful and factual. However, keep an open mind. The session will start jointly with all parties, and then I will meet with both parties separately and in confidence, sharing only information that the parties allow me to. These meetings are also known as caucuses. So if you hear me refer to a caucus, they're basically the separate meetings that we entertain. Again, during these meetings, these caucuses, I am able to obtain new information, and I'm also able to understand and assess new information and viewpoints that you are providing. This will allow me to evaluate the case better. Basically, consider me as your messenger. I facilitate communications, negotiations, ensure that everything runs smoothly. I will not tell you what to do. I will not tell you how to decide. This remains completely in the control of the parties. Finally, should the parties reach an agreement, a settlement agreement will be drafted. It will reflect everybody's understanding. All parties will sign it. And basically the agreement takes the form of a contract. However, if we only reach a partial agreement today, then we will explore other avenues. For instance, we might entertain another mediation session, or an arbitration, or a mini trial. So we have options. In closing, I appreciate your attention to my opening statement, and I thank you all for being here. And if you have no questions, I would ask who would like to start first. Thank you.